when you've got information about an employee that you think, oh, should I really be disclosing this? It's asking me questions that I'm going to need to blank out. Actually, for the sake of just knocking up a quick form of your own and putting a bit of branding on it, if you've got the flexibility to do that, then I would always suggest doing that. Just, you know, provide a table which would be, and I can find you an example document in a minute if you like, where it would literally just allow you to give the employee's full name, the last job title they held, when they started, when they completed, and ultimately that's it. And just a tagline that you say this is a corporate standard reference provision, and no further information shall be provided on the employee.
So
or whatever.
is the more juicy information from the personal?
With a personal reference, so sometimes a job might ask you, a company might ask you to provide a employment reference or 2 employment references, and then 1 character reference. And I'd always say that a character reference should be from somebody that's not associated with their employment, because if they list ex-boss because they know they got on with them really well and they used to go down for a drink at the pub on a Friday night, which, believe me, happens, and believe me, a lot of bosses think that's okay just to provide that reference. Actually, they do count as their last employer, and they are a representation of the organisation. So, you know, that individual could have left on bad terms, and it have been, you know, that there was theft or it was gross misconduct for whatever reason. But yeah, this boss, because he gets on with him and is his chum, writes him a really good reference and says, yeah, no, we never had any problems, such, you know, this, that, and the other. And that's when you get into a sticky situation, because if then that individual was to go and do whatever he's done in the previous organisation, do that in the next organisation, and there'd be another count of gross misconduct.
What sort of person should you have as a character reference then? Because my character reference is someone, you know, of good standing, but I did work with them.
Okay.
Would the teacher be good? Usually a past teacher?
Yeah, or it could be somebody that you have. So yeah, quite rightly though, I have used a colleague, so somebody that hasn't been my reporting line, but a colleague. So because you spend a lot of time at work, so you get to know people quite well at work, don't you? And actually, they understand you in the right realms of the information that the reference is asking for. So there probably is nothing wrong with a colleague, but I'd say definitely if it was a line manager, it becomes a bit difficult.
Okay.
All right. So, you all right? Yeah, I'm going to carry on. Okay. So, yeah. So resignation, usually very easy, usually very simple process, but there are circumstances where you do need to be a bit careful, and it's worth obviously thinking about if you're, so particularly maybe in your business page, there may be what we call intellectual property. So if there's patented ideas or there's company intelligence,
there's a thing in here, it is a note that you're not allowed to work for anybody you've had contact with in the company, or in
like a rival company within the next 6 months, I think.
6 months, crikey.
Yeah, that's
okay. I would say 6 months in a tribunal would be considered unreasonable. I think that would be considered unreasonable. 3 months is usually the standard, but recent case law has identified that if you don't make that clause within the contract, so yeah, it can be in the handbook, but when it's very generic, it's very hard then to apply.
Yeah.
So if you make it very specific, so for example, you've got to be very specific about the intellectual property relating to someone's job.
Yeah.
So for yourself, it could be personal information, but actually for somebody else, it could be particular devices and mechanisms and ways of calculating this, that and the other, and ideas about doing this, that and the other. It's completely different intellectual property, but just by having a blanket clause won't stand up in tribunal. That's from recent case law. So if you're going to include it in a contract, it's worth working with a solicitor or somebody that can help you identify exactly what that specific intellectual property is that relates to that job role. So for example, with account managers, so I know with our account managers, it will be pricing strategies and pricing structures for main contracts, Asda, Tesco, Boots, what do we do for them? Well, actually, what we don't want that individual to do is go and take that information and go and use it at a competitor and say, well, they're charging this, so we should charge that, you know, for example. So that's what those sorts of clauses are there for, but they do need to be really relevant to the job title. And if in the contract, again, if it goes into the contract as a blanket clause and it can't be seen to be very specific to that role and doesn't list specific accounts or specific customers, kind of won't really stand up. So it's a very difficult one to implement, because as well as needing to make it very specific, you also need to not refuse someone's right to work, which is against basic human rights. So you've got a lot of work to do if you want to implement that, but it's worth having, and I think sometimes it does just perhaps scare people off a bit, and it's worth having for generic purposes. But if you're going to put a blanket clause in, just know that it won't, other than scaring people off, it won't stand up in a tribunal.